that the foreign judgment will be conclusive. So before that, let's just know what is a foreign court. We had discussed in section 2.5. Foreign court is a court which is um, uh, outside India, not established or maintained by the central government. Then in that case, it will be a foreign court. And what is a foreign judgment? That has been defined in section 2.6 of CPC, which says that it is nothing but a judgment of a foreign court. And when a foreign judgment will be conclusive, so it says that ordinarily it will be conclusive, even if it has been delivered by a foreign court, it shall be presumed to be conclusive. But the exceptions are that when the foreign court which tried it is not competent, or the court actually did not hear the matter on merits and passed the judgment, or it is founded on in an incorrect view of international law. Basically, there is an international law which says otherwise, but an incorrect interpretation of international law gave rise to such judgment. Then in that case, it will not be conclusive. What do you mean by conclusive? That means it can either be a cause of action to be brought before an Indian court. So if it is not conclusive, then yes, it can be brought again. But if it is conclusive, then it cannot be brought again. So ordinarily, foreign judgments will be conclusive, except all of this. So we have discussed till C, that is for founded on incorrect view of international law. Then again, if it is on the basis of refusal to recognize an Indian law, then in that case also the foreign judgment shall not be conclusive. Fifth is when proceedings carried in order to reach to that judgment. The proceedings that were carried were opposed to natural justice. For example, we all know when our Indian diplomat was actually captured by Pakistan, and there they did not they made sure that there was no principle of natural justice followed, and in that case, it will the such foreign judgment of such foreign court will not be conclusive. Whenever it is obtained by fraud, if the judgment is obtained by fraud, by misrepresenting a fact, by actually making a fraud with the court, by not bringing a particular fact which is actually true and suppressing something, then in that case it will not be conclusive as well. Also, if it is on a breach of Indian law, then in that case a foreign judgment shall not be conclusive. Uh, then coming to section 14, that what will be the presumption that will be drawn as against the foreign judgments? Right? It says that if a certified copy of a foreign judgment is produced, then a shall presumption will be drawn. We all know what is a may presume, shall presume, and conclusive proof while reading Indian Evidence Act. We do not know, probably in the uh, next classes when we'll actually go ahead with discussing Evidence Act, then we'll study them. For now, you should know that shall presume means that the court will ordinarily constitute that such fact is true, unless and it will obviously allow that it can be the presumption can be shaken on production of other fact which says otherwise. So in that case, if the certified copy of a foreign judgment is produced, then a shall presumption shall be drawn that it has been produced or it has been pronounced by a court of competent jurisdiction. And such presumption can also be displaced as it is a shall presumption. If it was a conclusive proof, then it couldn't have been displaced. But here, it's such presumption that it is passed by a competent court can be displaced. Now coming to the main part of our discussion, that is place of suing. It starts from section 15, that in which courts the suits are to be instituted. It says that suits shall be instituted in the lowest grade of court competent to try it. That means if the court, if there is a case, if there is a suit which involves a land whose pecuniary value, whose value is 20,000, then you have to approach the lowest grade of court competent to try it. That means the civil judge or the civil judge junior division, which was previously known it like that. In that court, you have to file that case. You can't simply approach the district court or the high court at the first instance. The object of this provision is to make sure that the overburdening of higher courts are reduced, to make sure that there is a proper hierarchy of the forum that you actually uh, uh, go through while making a claim, and to avoid that you can't just approach any court or any forum that you feel like. So to avoid the forum shopping, also this provision has been done that the suit shall be instituted in the lowest grade court competent to try. For example, if it is the value is now 60,000, now civil court, I mean civil judge junior division is not competent to try it. In that case, you'll have to approach the civil judge senior division. So the whatever will be the lowest grade court competent to try it, and you have to approach that court at the first instance. Now coming to section 16, which says that suits to be instituted where subject matter situates. So the ordinary rule is that wherever the subject matter is situated, there the suits are to be instituted. So the suppose the suit the subject matter or the land is situated in Cuttack, then the ordinarily the courts of Cuttack shall have a jurisdiction over that, and not Bhubaneswar court over it. So so it says that suits are to be instituted within the local limits of whose jurisdiction the property situates. And in which cases will this ordinary rule of ordinary rule that wherever the subject matter is situated, the suit shall be instituted there shall be followed in these following cases. First is where you are dealing with a recovery of immovable property with or without rent or profits. So suppose you have given your property on lease or rent, and he's not either vacating it or not paying the rents or the profits arising thereof, then you'll have to make, wherever the property is, you have to file in that partition of immovable property. If there is a partition of immovable property you are claiming, which is in the local jurisdiction of a particular court, then you'll have to file in that court itself. If it is if it involves a foreclosure sale or redemption of a mortgage or charge, in that case also you'll have to file in a court which has the jurisdiction over that particular subject matter. Determination of any other right to interest in immovable property. In that case also, uh, you'll have to file before the court which has jurisdiction over that subject matter. Another is compensation for wrong to immovable property. So if there is a wrong committed to a immovable property, but you are claiming a compensation because somebody destroyed your immovable property, in that case, you can file where the subject matter situates. Also, you can file where the defendant voluntarily resides or carries on business or works for freedom. So basically, it acts on the principle of equity in personam. That means because you are claiming a compensation against someone, if that person is actually staying somewhere else, in that case, there also you can file your claim and it will be entertained. Next is where recovery of immovable property under distrent or attachment. In that case, if a movable property is attached, suppose your car is attached, or or a movable property which is it can be anything. If it is attached, in that case also, you want to recover that, this would has to be instituted where the subject matter is existing. But yes, of course, the such rules are to be subjected to the pecuniary or other limitations. So that means that yes, it's true that if the subject matter is within Cuttack, then you'll have to file the suit before the court in Cuttack. But yes, subject to the pecuniary rule. That means if it is more than 50,000, you can't file before a civil judge junior division. If it is below 50,000, if it is below 50,000, you can't just simply approach the civil judge senior division. Now coming to section 70, that is suits for immovable property situated within jurisdiction of different courts. There can be cases where a particular land is situated within the jurisdiction of both Bhubaneswar and Cuttack. What will happen in that case? So it says that if there is a property which is within the jurisdiction of different courts, then the suit can be filed in any such court. So it can be either filed in Cuttack or in Bhubaneswar. But you have to make sure that the entire property value is within the pecuniary limits. Basically, you can't say the whatever the portion that is under the court that you are filing. You can't just take that into account for determining the pecuniary limits. You'll have to take the whole property into account while determining the pecuniary limits, and then approach any such court within whose jurisdiction the property falls. So it can be either of the two. Now coming to section 18, which says that place of institution of suit where local limits of jurisdiction of courts are uncertain. So there can be cases where you do not know whether this the suit has to be instituted in Bhubaneswar or Cuttack. You're uncertain. So if you ask me any example where I mean when there can be a case where you'll be uncertain. So basically, if there is a suit for recovery of money, or if it is a money suit, because you had you had a certain deal with B, and B had actually promised to deliver the that money to you, and that you had a deal with B, and B had promised to deliver certain goods to you, and you had promised to pay him certain money, but you did not, and it is not sure where the cause of action arose, because the place of payment was not fixed, or otherwise for that matter. Uh, in that case, there will be uncertainty about the local limits of jurisdiction of the courts. If such thing is there, where there is an uncertainty that within whose local limits of jurisdiction the property or the suit should be filed, then in that case, the court before which it is filed can record a statement and then go ahead with disposing it. So basically, even if it is filed in a court, the court is of the view that right now I'm uncertain that whether it is actually within my jurisdiction or not, even then it can just record a statement that yes, there is an uncertainty of jurisdiction. Still then I'm going with the trial, and he can definitely go ahead with it. And this particular mode of disposal after recording, if he has recorded the statement to that effect and then goes ahead with the disposal of the same, such disposal will not be prejudicially be affected because of the lack of territorial jurisdiction. But yes, of course, it should make sure that the pecuniary limits are not exceeded, or the subject matter jurisdiction is not interfered. So basically, if a court there is a suit filed before a court, and the court is not sure that whether this is within my territorial jurisdiction or not. So in that case, it will have to what will it have to do? It will just record a statement to that effect that yes, there is this uncertainty that whether I should try the same, whether I should dispose the same, I'm not sure. But still, I'm just recording a statement to that effect and then go ahead with disposing it. And such disposal will not be prejudicially be affected, except if there is an avoidance of pecuniary or subject matter jurisdiction. So basically, if it is the court of small causes should try it, and the civil court now tried it, that won't count, and it will be prejudicially be affected because it hits to the root. But if it is uh, just because of the territorial jurisdiction somebody is challenging it, it will not be prejudicially affected. The statement regarding uncertainty has been recorded. Yes, if there is no such statement, then objection made regarding such lack of jurisdiction can be entertained. But yes, it will not be allowed except where if it is there is opinion that there was no ground for uncertainty, and there was a consequent failure of justice. So if that's the case, then only such an objection can be allowed. Now coming to section 19, which deals with suits for compensation for wrongs to person or movables. So it says that if there is a suit for claiming compensation for wrongs to person or movable properties, then it can be done at the option of the plaintiff, either at the place where wrong was committed or where defendant resides. So you'll have to know that if there is a compensation involved, always it follows the defendant. So it can either be filed at a place where the wrong was committed, or at a place where the defendant resides or carries on business, or works for gain. So if there is a compensation for wrong involved, I told you earlier also. So now coming to section 20, that what will be the fate of other suits? So we discussed certain suits. What will be the place of suing in those cases? Now coming to section 20, it says that if there is any other suit which doesn't fall within the categories mentioned before, then such suits ordinarily shall be filed either where the defendant is residing or where the cause of action is arising. And to further elaborate, it says that if there is a defendant or defendants, they are residing at one place, then it will be filed at that place. If there is a if there is at any other place of residence or work, either with the leave of the court or if the other defendants consent. So basically, uh, this the B part, it says that if there are more than one defendants and the suit and the defendants have residence at different places, so we are agreeing that yes, defendants wherever they reside or wherever they work for gain or wherever they have a place of business, in that case it can be filed there. But then what if the defendants, if there are more than one defendant and all of them reside at different places, in that case it can be filed at any of such place of residence of the one of such defendant, but except yes, of the fact has to be considered that the leave of the court has to be obtained, or other defendants will agree to the fact that yes, we have no prejudice if it is filed at the place of residence of A or B or C for that matter. See where else it can be filed, where the cause of action arises either wholly or in part. In Muhammad Hafiz versus Muhammad Zakaria, it was held that cause of action is what? Cause of action is the cause which gives occasion for and forms the foundation of the suit. We had discussed while discussing the elements of the suit that cause of action is actually the the cause which gives rise to the foundation of the suit. So without a cause of action, a suit cannot be entertained. Now coming to section 21, it says that objections to jurisdiction. It says that objections regarding territorial or pecuniary jurisdiction or competence of the court or the competence of the executing court. This is a long section. To cut things short, we have to know that if the objections there are there, that one person is actually wanting to object to the territorial jurisdiction or pecuniary jurisdiction of the court or competence of the court which has disposed the matter, or competence of the executing court which is executing the decree, in that case it will not be entertained by any appellate court or revisional court unless it has been taken at the earliest opportunity and before the settlement of issues. So we all know that the settlement of issues is the first step after the defendant comes, files the written statement. After the plaintiff is filed by the plaintiff, summons are done, then the defendant comes, files the written statement, then there is a settlement of issues. So if that thing is in a case where the settlement of issues are to be determined, in that case, before settlement of issues, one has to take such objection. So if the settlement of issues have been done, then it will be presumed that the objection regarding jurisdiction has been uh, uh, overlooked, and it will be presumed as if the defendant cannot take any other objection, or any person objecting to such jurisdiction of the court cannot further claim such uh, objections to jurisdiction. Yes, exception is there if even if he has not taken such objection at the earliest opportunity, even if it has not been filed before settlement of issues, if there is a consequential failure of justice, in that case such objection can be allowed. Now coming to section 21A, it says that bar on suit to set aside decree on objection as to place of suit. So it says that a suit challenging the validity of a decree on the ground of objections regarding territorial jurisdictions are not to be allowed. Basically, a suit was actually disposed, judgment was done on the grounds of that, a decree was drawn, and now someone is challenging that decree on the grounds of objections regarding territorial jurisdiction, that will not be allowed. Yes, a decree can be challenged on any other ground, but a decree cannot be challenged on the ground of a territorial jurisdiction. Again, this is all to make sure that there should be finality to the litigation. Why did you not take that ground on the suit itself? You should have taken that ground if you had an objection that there is a ground, there is this. You have an objection regarding the territorial jurisdiction, then you should have taken it at that first instance when the suit was being decided, not when the decree was drawn. There, your spar is seized. You can't now take that objection. Now coming to section 22 to 25, which deals with transfer of suits. So section 22 says power to transfer suits which may be instituted in more than one. So it says that if a suit can be instituted in one or more courts, we'll just remember this, that if it can be instituted in one or more courts and it has in fact been instituted in one court, then the defendant may at the earliest opportunity and before settlement of issues can apply to have such suit transferred to another court, and the court may decide where such suit shall proceed after hearing objections from the opposite parties. So basically, we had studied section 18 May. There was this thing that there is an uncertainty about local limits of jurisdiction of court, and there is a possible ground that you can actually file before two courts, or we studied where there was this option given that you can either file the suit at the place where the subject matter is situated or at a place is defendant is residing. So there are two courts uh, within whom you can actually shop for forums. So you can actually make sure that yes, this is the court that I want to file. So if there are two such courts, so section 22 says that if there are two such courts where the suit could have been filed, it has been filed in one court, then the defendant can at the earliest of opportunity and before settlement of issues can apply for a transfer of that suit, and the court can decide whether he shall proceed with the disposal of the suit or not. Section 23, that to which court uh, uh, such application under section 22 shall lie. It says that, of course, when I said that there can be an application, it does not mean that it will apply before the same court. It will apply to the courts that have been explained in section 23. So it says that an application under section 22, this is nothing but an extension of section 22. It says that an application under section 22 will be made to the appellate court if the conflicting jurisdiction courts are subordinate to the same appellate court. What do I mean by conflicting jurisdiction court? That means there are two courts before whom the suit could have been filed, but it has been filed before one court, and both the courts are within the jurisdiction, or they are subordinate to the same appellate court. Then the application under section 22 may be made to that appellate court. And here, if the conflicting courts are subordinate to different appellate courts but same high court, here the courts that are in question, they are not within the same appellate court. I mean, not subordinate to the same appellate court, but they are subordinate to different appellate courts. Then in that case, but here they are subordinate to the same high court. Then the application under section 22 shall be made to the high court. Now, if the conflicting courts are not subordinate to same appellate court, not subordinate to even same high court, and in fact are subordinate to different high courts, then before the high court within whose local limits the suit was brought first. So the suit has been filed. I told you that there are two courts where the suit could have been filed. It has been filed before one court. Then here, both the courts are subordinate to different high court, then before the court whose local limits the suit is brought, then before that high court or the application under section 22 is to be made. Now coming to section 24, that general power of transfer and withdrawal. So it says that the High Court or the District Court has the general power of transfer and withdrawal. High Court and the District Court. And when I say District Court, that means the District Judge. Uh, uh, and so uh, High Court or District Court at any stage of a suit, appeal, or other proceeding can order for transfer or withdrawal of a suit in these following cases. So, where the High Court or the District Court shall allow either on application of any party or suo motu. But if it is on the application of any of the parties, then the notice to the other party will be given, and the hearing of the such contradicting claims shall have to be done. But if it is a suo motu, then no such requirement are to be made, and the High Court and District Court can at any stage transfer and withdraw any suit. Of course, if it is on an application by any party, then it shall be done after notice to the opposite party and after hearing the contradicting claim. So here, if such application is made or the High Court or District Court suo motu believes, then in that case, it may transfer to any competent court, subordinate court, or competent subordinate court for trial. Basically, if a suit is pending before a district court or a high court, and the High Court or District Court is believing either on an application or suo motu that it should be transferred to another subordinate court for trial, then it can transfer it to any subordinate court. So basically, district judge can transfer it to an ADJ. But in subsection 3, it has been given that ADJ and assistant session judge, additional assistant and additional of both the judges, they shall be subordinate to the district court for this section. So the district court or the district judge can transfer it to any subordinate court, that is an ADJ, SJ, or civil judge, senior division, or civil judge, junior division, for a trial of the same. Or it can withdraw from any subordinate court. So basically, either it can transfer any suit pending before it to any subordinate court, or a suit is pending before a subordinate court, it may withdraw from that subordinate court and try it itself, or transfer it to any other subordinate court, or retransfer to the original court from which they had withdrawn it. So basically, there is this general power given to the High Court or District Court that within their jurisdiction they can do all this mix and match, and they can make sure that yes, this is the way the trial has to be done before this court, even though the jurisdiction was conferred with this court. I believe that for some reason it shouldn't be tried. There can be many reasons. There can be reasons a judge is actually wanting to recuse. In that case also, it can be transferred. So general power of transfer and withdrawal has been given to make sure that there will be convenience conferred on the district court or the high court in order to try and dispose with the suits. Now, what are these subsiding sections? That says that the new court which is trying the suit either can retry it from the beginning. That means it can either try it from the beginning or proceed from the point at which it was stopped. So it can either follow these two methods. Now I told you that ADJ and ASJ will be considered subordinate to the district court for the purposes of this section. Proceeding will also include a proceeding for execution of a decree or order, and it also says that if the original suit is pending before a court of small causes and it has been transferred to any other court, then the new court shall be deemed to be a court of small causes. So if it is pending before a small causes, even if it is transferred to a additional district judge, then that court will be deemed to be a court of small causes for that particular matter. Yes, under this section, suits can also be transferred from a court lacking jurisdiction. So if a court is lacking jurisdiction, in that case also a suit can be transferred. Now coming to section 25, that power of Supreme Court to transfer suits. So Supreme Court at any stage of a suit, appeal, or proceeding can, for the ends of justice, either not either, here only on application of any party. It cannot transfer suo motu. Here, if there is an application by any party, and there after notice to the other party, and after hearing the other party, can make an interstate transfer of suits either from high courts or civil courts. So this provision is also an enabling provision invested with the Supreme Court to make sure that if there is a need, that there should be an interstate transfer. There is a need because of any reason, and a party is applying for the same for the ends of justice. The Supreme Court can allow such interstate transfer from any high court to other high court, or any civil court from a state to other civil court within another state. Here, then, application to transfer shall be made with an affidavit, and the new court trying either can retry it or proceed from the point at which it was stopped. Yes, if it is a vexatious or frivolous claim of transfer, then compensation of up to 2,000 rupees can be given to the opposite party. And new court, here the new court shall follow the laws applicable to the original suit, appeal, or proceeding. For example, if the suit was transferred from Odisha, and suppose a particular law in Odisha was applicable to that, and it is now being tried in state of Karnataka, even though the law in Karnataka states otherwise, the laws of Odisha shall be applied to that suit because it was transferred from Odisha. General thing you'll have to also know as a Arbitration Act Section 8 to prevail over Section 9 CPC, which is said by Indian Drugs and Pharma versus Ambika Enterprise. I left this while dealing with Section 9 CPC, so thought of adding it. This more or less completes our transfer of suits. Before that, we discussed the place of suing, and before that, we discussed the foreign judgment. Along with Section 12 also, we discussed, which establishes a bar. If there is any bar imposed by rules, in that case also, the suit the suit institution can be barred because the rules shall be treated as a part and parcel of the sections. So all of this we discussed, and from the next class, so with this actually our introduction to CPC ends. With Section 25 it ends. Now we will proceed with Section 26 onwards, where we will actually give a cumulative reading of the sections along with orders, which will make sure that you get a clear picture that what orders are analogous to what sections, and how and in what order you'll have to read CPC, because reading CPC in that order is very important. So if there is one way to read it, that you either finish the sections and then read the orders and then in your mind jot down them. But the other way, which is the best way I believe, is actually to read the sections along with the orders. So in that case, your mind will make sure that yes, this is the section and these are the analogous orders, which actually should be read in consonance with the sections. In that case, it will be actually easier for you. So we'll do that from the next class. With this, our discussion somehow ends. Someone has asked that Section 18 someone could not follow, and then under 24, will High Court or District Court give notice to parties that he is transferring the case? First to again take you to the Section 18. Section 18 says that let's go back to the yes. Section 18 says that place of institution of suit where local limits of jurisdiction of courts are uncertain. So here the local limits of the jurisdiction of the courts are uncertain. So you do not know where to file it, because either there is a problematic jurisdiction, because this court, you can either file, you are of the opinion right now, the court is of the opinion right now, where you have filed it, that whether I should be actually trying it or some other court should be trying it. In that case, the court only has to do one particular thing, that is to record a statement to that yes, there is an uncertainty regarding jurisdiction, and then it can go ahead with disposing it. Even though it lacked jurisdiction, it won't prejudicially be affected if there is a statement recorded to that effect that yes, there was an uncertainty, I couldn't decide, and hence I am just going with the trial. And even though there was any such uh, lack of jurisdiction, lack of territorial jurisdiction, I mean, and in that case, it will be good to go and it will not be prejudicially affected. Except, of course, if it is pecuniary limits are not, not increased, not exceeded, or the subject matter jurisdiction is not interfered. And then the second question that was asked by you is section 24. Under section 24, whether the High Court or District Court has to give notice to the opposite party. Yes, if it is, as I discussed, that there are two cases where the High Court or District Court can file. One is when the High Court or District Court suo motu is of the view, or and the second is when there is an application made by the party. So if it is on the application made by the party, then the notice to the parties is a must, and hearing the opposite parties is a must. But if it is a suo motu proceeding where the High Court or District Court has thought to transfer the case itself, then in that case, notice is not mandatory.
Good evening, sir.
Evening.
Sir,
Good evening,
can you please give an example of section 17?
Section 17. Right. Section 17 says that suits for immovable property situated within jurisdiction of different courts. So I gave an example that I actually gave an example where you present in the class. If you were, let me just repeat it again, that if there is a property, immovable property, which is within the jurisdiction of different courts. For example, if there is a property which lies near Fulnakhara and which is actually the intersection of Cuttack and Bhubaneswar, and we do not know whether it is in the jurisdiction of Khordha or in the jurisdiction of Cuttack. Here there is a confusion that whether the jurisdiction should be going to Cuttack because yes, it is actually lying. Some part is actually lying in Cuttack and some part is actually lying in Bhubaneswar. In that case, here the plaintiff can go for filing the suit before any of the court. Any of the two courts, that either it can file the suit before the Civil Judge Senior Division Khordha if the pecuniary jurisdiction is more than 50,000, and if it is less than, then Civil Judge Junior Division Khordha, and if it can also file before the Civil Judge Junior Division Cuttack or the Civil Judge Senior Division Cuttack as the case may.
Sir, I am confused with the proviso part that provided that in respect of the value of the subject matter of the suit, the entire claim is cognizable by such court. So I am a little bit confused with that.
So the point it makes is that it's very, very simple. Don't try to overcomplicate it. Just know this, that in no case the pecuniary jurisdiction has to be interfered. So for that matter, even if some part of that particular land lies in Bhubaneswar and some part lies in Cuttack, and you are actually approaching Bhubaneswar, then also that particular court's pecuniary jurisdiction cannot be challenged or interfered with. So for that matter, you will have to take into consideration the whole property, and the value of that property. If it is more than 50,000, you can't approach the Civil Judge Junior Division. If it is less than 50,000, then again there is a bar that you will have to file before the lowest court competent to try it. So for that matter, you can't file before a Civil Judge Junior Division as well, and a Civil Judge Senior Division as well. You will have to file this before a Civil Judge Junior Division. So basically, know that even though you are considering half of the property and you are filing it before Bhubaneswar, then also you'll have to take the entire property into account while deciding the pecuniary jurisdiction. Because there was some part lying in Bhubaneswar, some part lying in Cuttack. You can't say that now I'm filing in Bhubaneswar, so the half of the property is in Bhubaneswar, so I'll have to just consider that property, and you can take that claim and try to bring down the pecuniary jurisdiction of the court and file it before a lesser court. So basically, again, this is to make sure that you don't avoid the court fees. So basically, if I take that plea, then I'll have to pay lesser court fee, because I'm actually saying that no, I'm filing it before Bhubaneswar. So only that part of the property which is within Bhubaneswar, that should be taken into consideration for pecuniary limits. The explanation or the actually makes it clear that you'll have to take the whole property into account while filing that particular suit. But yes, there is an option that yes, either you can file it before Bhubaneswar's court or Cuttack's court as well.
Thank you, sir. Thank you, sir.
Right. Akshay Kumar Sahu wishes us a happy Teachers' Day. Yes, happy Teachers' Day to you guys too, because you are not only I teach you something, I get to learn so much from you guys, so that I'm forever indebted that some whoever is coming to the class and attending it sincerely, asking me questions, for that I am also learning, and it's a forever learning curve, and I'm indebted to you guys. So happy Teachers Day to you guys too.
Happy Teachers Day, sir.
Thank you. So with this, we should end this lecture.
Yes, sir.
Suchitra,
Sir,
do
thank
you
you,
have
sir.
to say?
Teachers
Happy
Day.
Teachers Day, sir.
Okay, thank you so much, everyone. Thank you. I'm sorry that I can't take regular classes, and I'll only have to take on holidays. But then that's how it has to be for some days, until I find more time for you, and will then probably will take classes regularly. Happy Teachers Day once again. Have a great evening. Bye.